Good morning and welcome to today's oversight hearing on clemency in the Office of the Pardon Attorney. I would like to remind members that we have established an email address and distribution list that circulate exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has previously been distributed to your offices, and we'll circulate the materials to members and staff as quickly as we can. I would also ask all members, both those in person and those attending remotely, to please mute your microphones when you're not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Due to the size of our panels today, I will strictly enforce the 5-minute rule. I now recognize myself for an opening statement. During today's hearing, the subcommittee will examine executive clemency and explore solutions to improve the process of evaluating clemency petitions and making recommendations to the president. Although the authority to grant clemency vests solely with the president, the Office of the Pardon Attorney, a unit within the Department of Justice that is congressionally created and funded, aids the president in the exercise of the clemency power through an administrative process established by regulations that develop somewhat haphazardly. The rules, which were first promulgated by President McKinley in 1898, provide that clemency petitions are to be directed to DOJ and require the Attorney General to make a recommendation to the president on the merits of those requests. The relatively simple process for evaluating petitions and making recommendations evolved during the 1970s and 1980s, and now includes 7 levels of review, the first 4 of which reside within the DOJ. The Office of the Pardon Attorney, under the direction of the Deputy Attorney General, is responsible for processing petitions for executive clemency, reviewing case materials, vetting petitioners, and providing recommendations to the president. It is where the clemency process begins and ends for some petitions. Understanding the central importance of the Office of Pardon Attorney to a discussion about clemency and our committee's oversight over both the Department of Justice and the Office of the Pardon Attorney, I thought it best to have the Pardon Attorney participate in our conversation today. It is unfortunate that we were unable to reach an agreement with the Department of Justice to have the Pardon Attorney here to discuss how we can increase efficiency and account for and reduce bias in the clemency process, because as the Supreme Court has noted, executive clemency serves a vital role in the criminal justice system. We know so many families that are struggling with loved ones who deserve to have that consideration. And so I expect to have the Pardon Attorney here in the very near future, singly or for a briefing before this committee, singly in a hearing or at a briefing for this committee. It is imperative that all elements of this process come before this committee for our appropriate oversight. The framers of the Constitution understood that the criminal justice system needed a check that would guard against unjust or excessive punishments. Clemency can be a useful tool to right the wrongs of the failed war on many aspects of the criminal justice system and overcome misguided policies that led to mass incarceration by unburdening those who languish in prison or who suffer from the collateral consequences of their convictions. Certainly some of those were in the times of the excessive penalties for those who had basic possession in terms of drug cases, minimal drug cases with decades of sentencing and incarceration. If that is to be the case, Congress should encourage the president to use executive clemency and power routinely by fixing an apparently broken system and providing the president with the support he needs. That was done just a few weeks ago by President Biden. Clemency decisions should be made objectively, systematically, and with transparency. Yet we know that the modern clemency process cycles between periods of inaction and controversy, but there have been a few instances in the exercise of executive clemency that varied from what we have become accustomed and from what we must learn. In 1974, President Ford establishes the temporary Presidential Clemency Board and identified more than 13,000 clemency recipients following the Vietnam War. President Ford and Carter granted clemency the hundreds of thousands of men who evaded the draft. Then in 2014, DOJ, at the behest of former President Barack Obama, announced the Clemency Initiative, which focused on nonviolent drug offenders, so many that were incarcerated for decades. Despite initial problems in planning, implementation, and management through the initiative, DOJ substantially increased the number of recommendations to the White House, resulting in 1,696 individuals receiving clemency, appropriately so. Significant changes, which we would make note of, were made in the final year of the initiative that enabled DOJ to meet its goal of making recommendations to the White House on over 13,000 petitions. For example, DOJ temporarily increased staffing at the Office of Pardon Attorney to meet the demands of the initiative. The Office of the Pardon Attorney prioritized the review of petitions from individuals who were strong candidates for clemency, and DOJ streamlined the review process. Taking lessons from Obama's clemency initiative, we should consider whether there are incentives or measures Congress can implement to permanently streamline and shorten the timing of the review process to avoid the dilemma President Biden currently faces. I would have liked to ask the pardon attorney how she plans to tackle the backlog of 15,000 clemency petitions President Biden inherited over taking office in an efficient and just manner, or how Congress can help. We must also consider the longstanding criticism that there is an inherent conflict in the review process when it begins with DOJ if the president is to make better use of the clemency power. Since the pardon attorney is not here, I hope our witnesses can offer sensible solutions and proposals for reform of the clemency process, as well as ways in which clemency can be used as the framers of the Constitution expected. I thank each of our witnesses for their participation. I look forward to a robust discussion. Without objection, I will submit into the record the following documents: a New York Times guest essay written by Rachel E. Barkow, Mark Osler, entitled "We Know How to Fix the Clemency Process, So Why Don't We?" dated July 13, 2021. An entry from the Federal Sentencing Reporter, volume 34, by Mark Osler, entitled "The Role of the Clemency in Criminal Justice Reform." Let me also thank my colleague and Vice Chair, Congresswoman Cori Bush, for her interest in this hearing and her invaluable help as we proceeded to have this hearing and as we proceed further to secure the pardon attorney. And might I also mention with deepest sympathy to the families of those lost in Buffalo, New York, and those lost in accusation of guns and hatred. But as we proceed in this hearing, I hope that we will find as many facts as necessary to improve this process and to improve the criminal justice system. I now recognize the gentleman from Arizona, Mr. Biggs, for his opening statement. Mr. Biggs, you are recognized.